And it just kind of made sense to me that if you were going to get rid of something like that, with the decay of the smell of the swamp decay on either side of the road, it would have been a great place to hide it.
What strikes me is initially the statement by this witness was that he happened to be in the area, really didn't have any gut feeling one way or another, and just happens upon the remains of the child. He has now elaborated and is talking about his supposed expertise as a boarding officer, a bail bondsman, and a bounty hunter. And it now looks as though he devised a plan of investigation himself, and that's inconsistent with his earlier statements that I just happened upon the body. This gives the defense the foundation to question A, his motives, and B, whether or not this crime scene was contaminated or staged in some fashion.
He may have gone there before.
Absolutely. You know, at this point, I'm reminded that lawyers before trial regard their witnesses like children, which is they should be seen and not heard, and they should, in fact, not speak unless spoken to. This is a perfect example of this. As innocuous as his statement appears to be, it is building a great impeachment for the defense in this case.
But is that a concern of his? I mean, he's sort of a third party here.
He is a witness.
Is he unknowingly doing this?
Here's what bothers me about the fact that he's even making this statement. Ostensibly, he is making this statement because he is concerned that others have attacked him and vilified him. It has not been the defense that has done that. It's not been the prosecutors that have done that. That may be some court of public opinion, but that's irrelevant as to this trial. The focus of this witness, and the nice thing about this witness in the beginning was he realized the significance of what he found. He realized the significance of everything he says has a consequence. But now, regardless of the consequence, he's coming and making these statements, and he's giving the defense more information than they had to work with in the beginning, and you can bet they're going to explore this to the hilt. I would liken the discovery of this body to the discovery of the bloody glove in the O.J. Simpson case. What did the defense do in the O.J. Simpson case? They used Mark Furman to establish that there may have been tampering with the crime scene, staging of the crime scene through attacking Furman's character and motivation. The defense will use that attack, that very same tactic in this case, and that will then serve as the foundation where the defense will say, look, we can't trust the discovery of the body. We can't trust the integrity of that crime scene. Therefore, you jurors should disregard all of the circumstantial evidence that, or not circumstantial evidence, the forensic evidence that's coming from this crime scene. If they can convince a jury of that, or even one juror of that, that raises a reasonable doubt. The prosecution is then left, if you will, with the circumstantial evidence and Casey's inconsistent statements that she made prior to the discovery of this body. This could be a successful defense tactic in arguing for a not guilty verdict. Now, do we have the dream team in place here that O.J. Simpson had? Certainly maybe not as experienced as that team, but they're no fools. The saving grace for the prosecution is they are an A team. Burdick, Ashton, and George are deadly in their presentation, deadly in their prosecution. I believe that they'll have the ability to bring this back around and focus in on what the real issues are. But this witness has now given the defense plenty to work with, and they will attack the very foundation, that is the finding of the body and the crime scene and all the evidence that has been derived from that crime scene.
Okay.
I called. The officer showed up. I showed him a picture of the snake that we had found on Monday. He looked like kind of shaken up by it because it was a 6.5.
What I notice about this, and we'll comment a little more as you hear a little more, but the network has indicated, well, we did not compensate Mr. Crump for his appearance here, but we did pay a licensing fee for the photograph. If that's not thinly veiled compensation, I don't know what is, because a photograph of a rattlesnake, what significance does that have to this case whatsoever, much less to the point that a major news outlet is going to pay for a licensing fee? Very, very thinly veiled. And again, I think this gives the prosecution some, or strike that, we say strike that when
I grew up in a my mother is the district attorney, and my county has been for 20 years.
Well, please
she would say
forgive me.
strike that at the dinner table.
I know, I do too. My wife is always saying, you're not in court. But in any event, the defense will certainly say, in addition to other things, hey, he had a motivation to stage the crime scene, or he had a motivation to alter the crime scene in some fashion, and it is because he's getting some compensation. Now, his lawyer has indicated, well, wait a minute. If Roy can get some compensation from this, deservingly so. I say not. I say that this raises a very fundamental question of what have we become as a society where we think that we should be compensated for acts of a good citizen, or that we should profit in any manner off of the death of this child, much less a trial to determine whether or not this young mother is guilty of the crime of killing her own child.
Okay. What does this say about, are they going to use this to say, how hard did they investigate? I mean,
you know what, you hit the nail on the head, and I was going to let him, because he continues on a little more and says that it appears that the deputy was even rude to him and just kind of, look, we've got a lot of other tips. I don't see anything. You're wasting our time. You bet. The prosecution will then use this as a springboard to attempt to undermine the quality of the investigation in this case. Again, from all of the evidence that we have witnessed being gathered and all the efforts on the part of the Orange County Sheriff's Office, I believe that that will fall short, but it gives the defense the argument. And don't forget, all it takes is one juror to be convinced that there's a reasonable doubt based upon the quality of the investigation or the evidence, and you've either got a hung jury or possibly a not guilty in this case.
And that area is like a little embankment that goes down, and it's well protected from the road. You can't see anything because of all the growth. So I had to go to the bathroom. So
he has just contradicted what he said earlier in his statement, which was, I went there because of my prior experience as bounty hunter, as bondsman, as boarding officer, and I felt that if someone were going to dispose of a body, this might be where they dispose of it. The defense, again, will seize upon the fact that he's making inconsistent statements within the statement that he's made right now, called internal inconsistent statements. These statements are probably, if you examine earlier statements by this witness, inconsistent even with his earlier statements. So again, a lot for the defense to make of these statements that he is making on camera.